Hello everyone and welcome. I'm Kristen at TSIB. We are here at TSIB's Construction Risk Management Seminar, Day 2, and we are so excited to have you with us. I'm going to introduce our speakers in a moment, but first a couple of housekeeping notes. This session is pre-recorded, but we will have a live Q&A at the end. We ask that you stay on mute and off camera during the entire presentation. Both speakers, Mike and Nick, are here with us today. So if you have any questions, you can post them in the chat feature located at the top of your screen. Nick and Mike will also be chatting with us during the entire presentation. So as you're watching the video, you can post anything in the chat. But again, we will have plenty of time at the end of the session for questions. This entire session, including the Q&A, will be available on demand on TSIB's YouTube channel. Lastly, the material covered during this session presentation is for informational purposes only. It should not be construed as legal advice, and it is highly recommended you contact your attorney for legal advice. So without further ado, I'm going to introduce our speakers. We have Nick Langer, a senior risk advisor at TSIB, and Mike Langer, risk advisor at TSIB. They are presenting Understanding Additional Insured Endorsements and their relationships to your contracts. We are so excited to have you both here with us today. Why don't you each say a quick hello to everyone, and then we will get started.
Thank you, Kristen. Yeah, good morning, good afternoon. Welcome, everybody. Thank you for joining us. We look forward to getting you some information on additional insured endorsements and look forward to speaking with you after.
Thank you, Kristen. Thank you, Mike. Nick Langer here. Folks, this is somewhat of a dry topic, so please, as we're going through this, don't hesitate to fire off any questions to us, and we'll be happy to answer those questions. So, Kristen, why don't you get us started?
Great, thank you both. So without further ado, we'll begin.
Welcome, everybody. Thank you for joining the Construction Risk Management Seminar on Understanding Additional Insured Endorsements. Today, we are going to be discussing the relationship between your insurance coverage and the construction contracts you enter into. My name is Mike Langer. I'm a risk advisor with TSIB, and before we begin, I'd like to introduce my co-presenter, Nick Langer.
Thank you, Mike. Hello, folks. My name is Nick Langer, and I'm a senior risk advisor with TSIB, Turner Surety and Insurance Brokerage. To further Mike's introduction, we will be diving into the principles of contractual risk transfer and emphasizing the relationship between your contracts and the additional insured endorsements available under a commercial general liability policy. While additional insured issues can arise other coverage lines, the general liability policies where the most complex additional insured issues arise with respect to construction contracts, and ultimately the purpose of our presentation today.
Before we begin, I do have to remind you that we are not attorneys and none of the information presented can or should be considered legal advice.
Before we dive into the meat of our presentation today, it's important for us to provide a brief narrative on the basic principles of risk management. For today's purposes, we're going to talk about the three basic categories of risk. Those are business risk, strategic risk, and hazard risk. And typically, most people tend to focus their perception of risk management or risk on hazard risk. It's very easy because it refers to bodily injury or property damage type situations. Strategic risk refers to the external influences that can negatively or positively impact your business. And business risk is very much focused on the internal issues that arise within a business, things ranging from human capital to perpetuation planning and so on and so forth. When it comes to any type of risk, there are 5 basic ways to address risk. We can first and foremost always prevent or simply avoid a risk altogether. Our next option is to mitigate risk. Risk mitigation comes in a variety of forms, but most notably, risk mitigation is where we see all of our safety and training and planning efforts utilized to try and minimize the potential impact of a loss associated with a risk. Next, we can take the option of transferring our risk onto another party. We can do this through a variety of ways. However, today we're going to be focusing specifically on contractual risk transfer, where we're transferring risk from one party to another party. Utilization of insurance programs are another way in which risk can be transferred. Besides preventing risk, mitigating risk, transferring risk, we can also finance risk and assume risk. But what I like to share with everybody, specifically in the construction industry, before a decision is ever made in which we say, forget it, let's let the cards fall where they may, we should have gone through a very thorough risk management analysis to decide that the risk assumption is something that makes sense, and this has been a calculated decision.
Many contract provisions can affect the allocation of risk in a transaction, and the treatment of risk in a contract can only be understood by reading the entire document. Essentially, indemnity clauses alter the liability that is allocated between contracting parties by requiring one of the parties to indemnify the other for certain types of liability to third parties. I'll expand on this more in just a minute, so we'll keep this brief for now. Liability limitations and exculpatory provisions within a contract also alter the application of legal liability principles. Rather than requiring one party to indemnify another for liability to a third party, they relieve one contracting party from liability to another contracting party. This liability waiver or limitation is usually intended to apply regardless of whether the injured party has purchased insurance to cover the risk. The contractual requirement for a waiver of subrogation is used similarly to liability limitation provisions in that they waive one contracting party's right to pursue recovery from the other contracting party. However, they generally apply only to the extent that the other party is covered by insurance for its loss. Contractual insurance requirements impose specific coverage requirements on one or both contracting parties and generally require evidence that these requirements have been met. Insurance requirements are detailed within a contract for a variety of reasons. First, to assure the financial viability of an entity's business partner. Second, insurance requirements within the contract are also utilized to provide for a coordinated and efficient insurance program for the project. Additionally, upstream parties impose insurance requirements to fund the recovery of damages inflicted by the negligence of the contracting or downstream party. As the title, contractual risk transfer indicates, insurance requirements within the contract exist to ensure the risks assumed by the indemnity provisions of the contract are allocated to the contracting party.
Before we continue discussing risk transfer, it's important to understand some basic concepts of indemnity. The intent of risk transfer is simply to shift potential risks to another party. Risk transfer by way of a contract is accomplished most directly by means of what we refer to as an indemnity agreement, or a provision in the contract in which one party, the risk transferor or indemnity, requires the other party, the risk transferee or indemnitor, to accept responsibility for some portion of the first party's legal liability. Accepting such responsibility is referred to as indemnifying the other party or holding the other party harmless. The terms indemnity agreement and hold harmless agreement are often used interchangeably to refer to the part of a contract in which the risk transfer is actually accomplished. Indemnification agreements are the subject of much attention and dispute. This is not limited to the court system. It also extends to statutory regulations in many states that have passed what we refer to as anti-indemnity statutes, applicable specifically to the construction industry. Anytime you execute a construction contract, whether as a GC or an owner, developer, or subcontractor, you should have a basic awareness of the legal framework underlying indemnification agreements and the liabilities assumed. There are a couple of very important points to address as respects indemnity. First, the transfer of risk should be completely independent of insurance coverage. The indemnitor will generally be required to respond whether its obligation is insured or not. The existence and scope of any insurance coverage does not usually govern the extent of liability transfer within a contract. This is very important. If you are a party to a construction contract and you are agreeing to some form of an indemnification, whether or not you have adequate insurance coverage, whatever liabilities you have assumed through that contract will not go away should you not have adequate insurance coverage. The second important note to discuss would be that the indemnity agreement does not relieve the indemnity of liability to an injured third party. The indemnity will be held liable to the third party and must pay damages to the injured party whether or not the indemnitor responds to its obligation to indemnify. So for example, if a subcontractor, in this situation would be the indemnitor, does not have the financial resources to respond to its obligation to indemnify the indemnity, in this situation the general contractor will still be required to pay damages to the injured party. There are different types or levels of indemnity. We'll start by looking at a broad form or type 1 indemnity. Under a broad form indemnity, the indemnitor assumes an unqualified obligation to hold the indemnity harmless for all liability associated with the subject matter of the agreement, regardless of which party is at fault. Even if the damage, injury, or claim is due to the sole negligence of the indemnitor must respond to the loss. Ultimately, a broad form indemnity provision transfers the entire risk of loss from the indemnity down to the indemnitor. In layman's terms, if I break it, I buy it. If we collectively break it, I buy it. And if you break it, I buy it. The second type of indemnification is what we refer to as an intermediate or type 2 indemnity. Here, the indemnitor assumes all liabilities of the indemnity relating to the subject matter of the agreement, except where the injury or damage is caused by the indemnity's sole negligence. Any amount of fault on the part of the indemnitor under the intermediate hold harmless agreement obligates the indemnitor to indemnify the indemnity for the total amount of damages. For example, whether the indemnitor is 10%, 90%, or 100% at fault, it must indemnify the indemnity for 100% of the damages. The only instance in which the indemnitor is relieved of the contractual obligation to indemnify is when the loss is again due solely to the fault of the indemnity. In other words, if I break it, I buy it. If you break it, you buy it. And if we break it, I still buy it. Depending on the state in which you operate, it's important to understand what is and what is not acceptable contractually when enforcing an intermediate form indemnity.
This third type of hold harmless agreement is sometimes referred to as a comparative fault indemnification agreement. And as the name implies, this agreement obligates the indemnitor only to the extent of its own fault. So essentially, if I break it, I buy it. If you break it, you buy it. And if we break it, we each contribute to our share of the loss.
Now that you have some basic understanding on indemnity, we need to examine the relationship between your insurance cover and the indemnity language in your contracts. The primary objective in requesting additional insured status under the indemnitor's liability policy is in securing coverage as backup to the indemnity clause and in obtaining what we refer to as a duty to defend from the insurer. In some states, it is also possible to obtain coverage under the insurance policy for liabilities that cannot legally be transferred in an indemnity agreement. Transferring risk through an indemnity provision creates contractual liabilities for the indemnitor. Many of these contractually assumed liabilities are covered by the indemnitor's general liability policy. However, contractual liability under a general liability policy is contingent on a legally enforceable contractual obligation, and many states place limits on the transfer of liability for one owns negligence or sole negligence. If an indemnity provision is found to be in violation of a statutory or judicial limits on contractual risk transfer, or if a particular loss is deemed to be outside the scope of the indemnity provision, there is no legal obligation on the indemnitor to pay. As a result, the indemnitor's general liability policy will not be triggered by the claim without having named the indemnity as an additional insured. While most states prohibit at least some degree of transfer of liability for one's own or sole negligence, only a few states currently prohibit the purchase of insurance that covers another party for its own negligence. Most anti-indemnity statutes don't address additional insured coverage requirements.
To elaborate, there is a quasi-governing body, the Insurance Services Office, aka ISO, which collects statistical data, promulgates rating information, develops standard policy forms, and files information with state regulators on behalf of insurance companies. Over the years, ISO has developed a number of standardized policy forms and endorsements utilized by insurance companies in the issuance of insurance coverage. When it comes to additional insured endorsements, we need to start from the beginning to fully understand the progression of additional insured language over the years. So in 1985, the CG 2010-1185 additional insured endorsement was the first additional insured endorsement created for the CGL policy. The 1985 endorsement provided language which names the indemnity as an additional insured for liability arising out of your work. When you read your construction contract, you'll most likely see a requirement to name the indemnities as an additional insured using the form CG 2010-1185 or something equivalent. The original additional insured endorsement didn't have many limitations. This endorsement simply stated that the liability must arise out of the named insured's work and did not make any distinction between ongoing and completed operations. In 1993, ISO began distinguishing between ongoing and completed operations and revised the CG 2010 endorsements to exclude completed operations coverage. The insurance company desired this change to reduce exposure to lawsuits filed long after construction projects ended. The endorsements use the phrase arising out of your ongoing operations, however, which again proved somewhat ambiguous. Insurers and insureds debated the meaning of the phrase ongoing operations for many years, and ISO again addressed these ambiguities in 2001 by adding exclusions to the 2010 endorsement. The 2001 endorsement specifically excluded bodily injury and property damage occurring after all work has been completed or that portion of your work that has been put to its intended use. These 2001 revisions also forced the creation of a new additional insured endorsement, CG 2037, which provided the previously lost completed operations coverage for the additional insured.
As you'll see on the chart, it's important to note that there's a variety of numbers following the letters CG. The first two numbers are the form number itself, CG 2010, CG 2037. The second two numbers on the endorsement refer to the date of publication by ISO. In 2004, ISO introduced the most significant change by deleting the arising out of language from the CG 2010 and CG 2037 additional insured endorsements, respectively for ongoing and completed operations. And instead, it used the word or the phrase caused in whole or in part, in reference to the acts or omissions of the named insured or those who are acting on behalf of the named insured. The main purpose of the 2004 revisions was to avoid providing coverage for losses that arose out of the operations that were caused solely by the additional insured's act or omissions. If you remember back to our discussions about the different types of indemnity, this change very much mirrors what we see in a type 2 or intermediate form indemnity. Due to this change to the forms, however, many contracts will still seek additional insured coverage for the indemnities by use of the older 2001 version of a CG 2010 endorsement. And for that same reason, insurance carriers are more reluctant to issue that version of an additional insured endorsement. That brings us now to the 2013 endorsements. These endorsements narrowed coverage yet again, such that the language reads, Insurance afforded to an additional insured only applies as permitted by law, and the coverage afforded will not be broader than that which you are required by the contract or agreement. The endorsement also contains an additional restriction on the limits of insurance, such that if coverage for the additional insured is required by contract, the insurance is limited to the lesser amount of 1, that amount required by contract, or 2, the available limits under the insurance policy. The first change, limiting the coverage to the maximum extent permitted by law, does not actually reduce coverage. A court would not enforce an endorsement that violates a statute or something that goes against public policy. In many ways, this clause is actually more of a clarifying statement. The second and third changes, however, do actually reduce the scope of coverage that is provided to the additional insured through the use of the 2013 endorsements.
To further the evolution of additional insured coverage, we would be remiss not to address blanket additional insured endorsements. Blanket, also called automatic, additional insured endorsements are provided to automatically add as an additional insured individuals or entities for whom the insured is performing operations and with whom the named insured has agreed in writing to name as an additional insured. A positive feature of the blanket endorsements is in the fact that insurance agents and brokers can often send out these endorsements without requesting permission from the insurance carriers, which often makes the blanket additional insured endorsements quicker to process. However, a negative feature is the written contract requirement. However, in many situations, you'll see insurance carriers still utilize a CG 2010 or CG 2037 additional insured endorsement and add or manuscript additional language on the endorsement itself, stipulating that additional insured status is granted to any party in which a written agreement has been executed. The CG 2010 is very similar to a CG 2033 in providing coverage to the named insured for ongoing operations. The major difference here being that CG 2033 requires that there must be a written contract or agreement between the additional insured and the named insured. The primary distinction between the CG 2033 and the CG 2038 endorsements is that the CG 2038 provides coverage for upstream parties. Upstream parties are entities or individuals above the level where an entity is contracting. So while the CG 2033 only provides additional insured status where there's a direct written contract, the CG 2038 extends coverage to any other person or organization you are required to add as an additional insured under the contract or agreement.
In 2009, we continued the progression of the additional insured endorsement, and ISO issued yet again new endorsements to address additional insureds on the general liability policy. Additional insured coverage for completed operations has generally been provided using a form CG 2037. Which requires each additional insured to be listed in the endorsement schedule. The new ISO endorsements automatically extend additional insured coverage for completed operations without having to specifically identify each additional insured. Therefore, these new endorsements really mirror the current blanket additional insured endorsements for ongoing and completed operations, forms CG 2033 and forms CG 2038 that Mike just spoke to. The new CG 2039 and CG 2040 correspond with the CG 2033 and CG 2038 for ongoing operations. They're sort of like peanut butter and jelly. The CG 2039 and CG 24 are for completed operations, and the CG 2033 and CG 2038 are for ongoing operations. Both forms need to be utilized in order to provide adequate protection to the indemnities, right, or the additional insureds. The CG 2040 does provide superior coverage for owners and contractors, as there's no requirement for direct contractual privity between the additional insured and the named insured. The CG 2040 provides additional insured coverage literally to anyone required to be named as an additional insured under the written contract. In contrast, The CG 2039 requires a direct contractual relationship with the named insured, stipulating that additional insured coverage only when you and such person or organization have agreed in writing or in a contract or agreement to be named as an additional insured on your policy. Policyholders also need to be aware that there are two important distinctions between the 2039 and the CG 2040. First, the additional insured coverage under the CG 2039 and CG 2040 is conditioned upon the named insured having agreed in writing to a contract and providing such coverage. And again, I want to emphasize the original pure form, unmanuscripted form of a CG 2037 does not actually require any such written agreement to exist. Additionally, the CG 2039 and 2040 expressly exclude certain professional liability services. This is not something that we saw on the older CG 2037 versions for completed operations coverage.
So we wanted to end with some strategy here, and the key to effective transfer of risks in a contract usually lies with the indemnity who drafts the hold harmless and required insurance provisions of the contract. Effective, knowledgeable, and realistic contract provisions which express clearly the risk allocation intent of the parties and do not impose onerous, impossible, or vaguely worded duties to the other contracting party will guarantee the risk transfer takes place enforceably and in a way that reflects the best interest of both parties. As discussed previously, many states impose restrictions on types of risks that can be transferred to another party, even when restrictions are not accomplished by statute. Common law may impose limitations on the enforceability of certain risk transfers. The best way to ensure the enforceability of an indemnity provision is to have knowledgeable legal counsel develop indemnity clauses that conform to the applicable statutes and common law requirements. Since indemnity agreements and other transfer techniques are only as good as the indemnitor's financial ability to meet its contractual obligations to indemnify, indemnity should take reasonable steps to assure the needed funds will be available when a loss occurs. This is usually obtained by requiring indemnitors to carry insurance that will respond to their contractual obligations. As with other contract terms, indemnity and insurance provisions are typically negotiable. The final provisions are often largely dependent on the relative negotiating positions of the parties and the importance of the deal. However, it's not always in a party's best interest to impose broad risk transfers and insurance requirements just because it can. A better approach here is to determine what level of risk transfer and what supporting insurance requirements will provide an acceptable degree of protection to that party, which can be complied with and documented without the need for extended and further back and forth negotiations. The process of understanding, negotiating, and documenting compliance in itself consumes considerable time and effort and can add to the overall cost of risk transfer without actually achieving any added protection for the indemnity. Requirements can quickly become outdated, so indemnities should have a knowledge insurance professional, usually a risk manager or an insurance broker, periodically review the insurance requirements they impose to others and identify outdated terminology and policy modifications. As we've seen so far, indemnities should also require additional insured status under the indemnitor's liability policies. As insureds, rather than merely indemnities, you'll have direct access to defense coverage for insured claims, and in addition, coverage will not be dependent upon enforceability of the hold harmless provision and will remain in place even if the contract's indemnity provisions are found to be unenforceable. Although most indemnities require indemnitors to provide evidence that required coverages are in place when the contract is executed, many don't monitor compliance with this requirement. Because the underlying coverages are the backbone of the risk transfer, you should take reasonable steps to confirm that the required coverages are in place and establish an organized certificate management system to monitor compliance with insurance requirements and serve as a permanent record of coverages.
By developing a strategy for dealing with contractual risk transfer, indemnitors can often reduce the amount of risk they assume and avoid cumbersome and unreasonable insurance requirements. The first step for controlling the assumption of risk is to establish a process for performing a risk management review of contracts to identify potential risk and insurance problems. This is something that should be done internally. This is something that should be done with your attorney, and this is something that should be done involving your insurance broker. Rather than letting indemnities dictate the allocation of risks, indemnitors should take an active role in negotiating the contract terms that are reasonable and workable within their own insurance programs. Many indemnities are willing to make reasonable changes in their requirements to reduce conflicts or to improve the contracting process as long as they're still receiving adequate protection. This one should go without saying, but you need to read the entire contract. Risk can be transferred virtually anywhere in any contract provision. Coordinating additional insured status with the indemnity agreement is important because if the indemnitor is not careful, providing additional insured status may end up undoing the effectiveness of some of the contract provisions you've worked so hard to negotiate. Frequently, insurance companies resist or refuse attaching manuscript endorsements, particularly those drafted unilaterally by other parties. By demanding forms that are difficult, costly, or impossible to obtain, indemnities introduce additional costs and barriers into the contracting process. The indemnitor may be forced to choose among breaching its own contract, moving their insurance coverage to another insurance carrier, or ultimately withdrawing from the project altogether. Indemnitors may be able to avoid these frustrations by educating the other parties that they're working with as to why their proposed modifications are unnecessary or unrealistic given the contractual relationship. Businesses that routinely add others to their policies as an additional insured should be utilizing blanket endorsements. This avoids the risk of anything falling through the cracks. This avoids an error or omission by your insurance broker or the insurance company itself. Businesses that agree to indemnify others for claims against those other parties increase their total liability exposure with every single contract they execute. For that reason, your aggregate liabilities assumed in all contracts should be taken into consideration when selecting the appropriate insurance limits for your insurance program. While some indemnitors take the position that as long as they've secured enough coverage to satisfy that particular contract, you may not actually be guilty of breaching that contractual obligation by not having adequate insurance. However, if inadequate insurance limits have been maintained, you will still be liable for those claims. In the end, it's important to partner with an insurance broker and an attorney who have extensive experience and knowledge in the area of contractual risk transfer in the construction industry to help you safely navigate your contractual obligations and your risk transfer strategies.
So again, quick reminder, we're not attorneys and none of the information presented today can or should be considered legal advice. More importantly, thank you for joining us in the seminar. Should you have any questions, please feel free to contact Nick or myself at any time. Our contact information is listed above and can be reached at any time.
Thank you very much, folks. We appreciate you joining us today. Have a good day and be safe.
Thank you, guys. That was a great presentation. So now we're going to open up our Q&A portion of the session. As a reminder to our guests, if there are any additional questions you have, please enter them into the chat box at the top right, and we'll be answering them now. So some questions did come in. The first question is, how often do we obtain additional insured endorsements for our subcontractors?
That's a good question, and I'll take this one if you don't mind, Mike. Before I answer that question specifically, what's important to understand is if you are a contracting party issuing a subcontract downstream, the most important thing to do first is to execute a well-written subcontract agreement with your downstream parties. Within that subcontract, as we talked about, that subcontract will dictate the expectations of the relationship between you and your subcontracting party. So within that subcontract agreement, it will dictate the indemnity that you're expecting from your lower tier subcontractors. And in addition, that subcontract agreement will stipulate what insurance coverage should be brought to the table by your subcontractor. It's important to note that you have to have a written agreement in force in most situations for an additional insured status to actually be enforceable with the insurance company. So the short answer about how often should we get additional insured endorsements is on every project, right? Every time you're issuing a subcontract agreement or you're issuing work downstream to a subcontractor, you should be expecting that you are gaining the protection of being listed as an additional insured on their policy. But it's not simply the additional insured endorsement. As we mentioned earlier, the indemnity language and the additional insured coverage kind of work together like a peanut butter and jelly sandwich.
That's a great answer. Thank you, Nick. The next question that came in is, who should be receiving and checking endorsements?
That's a good question. I'll take that one. Two notes here. So first of all, it should be somebody who understands additional insured endorsements. And secondly, I think it's beneficial to have at least two set of eyes on each check of insurances and additional insurance endorsements. So I'll say that this is a service we provide our clients to help ensure that they're receiving the insurance that's expected under the contract. And again, it's important to have at least one or two individuals internally who understand additional insured endorsements and the ramifications of each versions that are afforded to you. We also provide training to our clients on this to help them understand the whole process and be able to communicate with subs or GCs and negotiate what's needed for them per contract.
That's great. Very informative. Another question that came in, what happens if my policy or our subcontractor's policy can't issue the endorsements we need?
So unfortunately, if this happens and the carrier is unwilling to issue a certain version of endorsement, or your client is unwilling to accept a different form, then on occasion, unfortunately, we'll have to switch insurance companies. This also ties hand in hand to partnering with a broker who understands your industry as construction. There's certain carriers who just don't offer specific endorsements. So upfront, we'll know who's a better carrier, who's a good fit for you as a GC or a subcontractor. And again, I mean, unfortunately, that's something that might have to make a midterm move, but also very important to have a broker on your side who understands your industry and your business specifically.
If you don't mind, I'm going to piggyback off of that, Mike, and real briefly, I want to note that if it gets to that point, you should have exhausted all communication efforts with your client. And I know we have a lot of clients that, and a lot of folks, especially as you start to deal with larger and larger owners and working on larger projects or working as a subcontractor to larger general contractors, there's this sort of fear that we see a lot where it's like, I don't want to rock the boat, right? They're issuing me a $1 million, a $5 million, pick a project size. We're receiving this contract and we don't want to rock the boat to potentially lose it. But these conversations, these interactions between the owner and the general contractor or general contractor and sub-tier subcontractors, these are common discussions that take place. So you should be involving your broker in those discussions so that they can advocate the reasons why your insurance carrier may be unwilling to issue a certain version of an additional insured endorsement or whatever endorsement's being requested. So before you get to that point, please, I do encourage everyone, it's not going to jeopardize your contract if you pick up the phone and call your contractor and say, hey, you know, my insurance company has said we won't issue this for X, Y, and Z reasons, and at least give yourself the opportunity to plead your case before you're forced into this pigeonhole of having to switch coverage.
That's a great answer. Thank you both. I don't see any more questions in the chat. So thank everyone. Thank you all for coming and spending time with us today. Don't forget to join our next session, Should You Bond Back Your Subs? That link can be found on your seminar program page on our TSIB's website or in the reminder of events email you received earlier this week. See you in a bit. Thank you guys again for speaking.
Thank you again, Kristen.
Thank you. Have a
Bye.
great day.